Hello, everyone, and welcome. Just a few minutes while attendees join. Hello, everyone, and welcome. Welcome to the 81st meeting of the Native American Graves Protection and Repatriation Review Committee. My name is Melanie O'Brien, and I am the designated federal official to the review committee. Before we begin, I would like to remind everyone that this meeting is being recorded. The recording, transcripts, and meeting minutes will be made publicly available after this meeting and will include the names of those in attendance during today's call. If you object to this, you may disconnect at this time. Excuse me just a minute, technical issue with one of our presenters. This is a public meeting of a federal advisory committee established by the Native American Graves Protection and Repatriation Act, or NAGPRA, of 1990. And this meeting is held under the Federal Advisory Committee Act, or FACA, and its implementing regulations. This meeting was noticed in the Federal Register on April 4th, 2022. An agenda for this meeting, as well as meeting materials, are posted to the NAGPRA website, the NAGPRA events page, and I will post a link to that in the chat. You will just give me 1 minute while I assist one of our participants with joining the meeting, and then we will resume. Thank you for your patience, everyone. Just 1 minute while I assist one of our presenters with connecting. Sorry, I apologize for the delay. Okay, hopefully that will work. This is the problem when only one person has the control of the Zoom account. Okay, back to our introduction. Excuse me. This is the 81st meeting of the review committee, and the Secretary of the Interior has issued a charter for this review committee, which governs its objectives and scope of activities. The purpose of the review committee is to monitor and review the inventory and identification process and repatriation activities under sections 5, 6, and 7 of the Act. The review committee is also responsible for reporting to Congress on the progress and any barriers encountered in carrying out its responsibilities. With that as an introduction, I'd like to start with a roll call of the committee members. Please answer out loud. John Beaver.
Present.
Timothy McEwen.
Present.
Frank McManaman.
Present.
Shelby Tisdale.
Present.
Honor Keeler. And Barnaby Lewis. Okay, I had heard from Mr. Lewis that he would unexpectedly be unable to attend today's meeting. I had not heard from Ms. Keeler that she would not be in attendance, so hopefully she will join us, and I will indicate so if she is able to. Currently, the review committee has 6 appointed members. The charter for the review committee does not contain a quorum requirement, and a meeting may be held with fewer than 7 members present. Although we are missing 2 members today, I have determined that we can proceed with only the 4 members that are present. So I hereby call this meeting to order. I would like to acknowledge the individuals that are assisting me today in conducting this meeting. With me are 2 attorneys from the Department of the Interior Office of the Solicitor. Brady Blasco is with the Division of Parks and Wildlife, and Stephen Simpson with the Division on Indian Affairs. From the National NAGPRA program, Lisa Koszalski is the review committee coordinator who is responsible for organizing this meeting and preparing minutes and transcripts of the proceedings. Although we usually begin these meetings with a traditional opening, the absence of Mr. Lewis has prevented us from arranging that traditional opening. In lieu of this, I would like to take the opportunity to acknowledge that this is Public Service Recognition Week. I would like to acknowledge the service of the federal staff of the Department of the Interior and the National NAGPRA program, as well as the members of the review committee who during your tenure serve as special government employees. I would also like to recognize all of you in attendance today who serve our nation as state, county, local, or tribal government employees. Together, we are doing important and critical work that has a positive impact on our nation and on our future. Thank you each for your service. To begin our first agenda item today, I'm pleased to introduce 2 additional public servants of the Department of the Interior who are with us today. The Assistant Secretary for Fish and Wildlife and Parks, Shannon Estenoz, and the Assistant Secretary for Indian Affairs, Bryan Newland. Both the Assistant Secretaries were nominated by the President, confirmed by the Senate, and sworn in by the Secretary of the Interior. Both have extensive experience and impressive resumes, and they bring a wide variety of experience and expertise to the responsibilities that they shoulder at the Department of the Interior. For our purposes here today, both the Assistant Secretaries have responsibility for issuing regulations under NAGPRA on behalf of the Secretary. Assistant Secretary Estenoz, would you like to begin?
Yes, thank you, Melanie, and hello, everyone. It's good to see you. I apologize for dialing in late. I had a Zoom snafu that you would think that I would have figured out in the last 3 years, but so I apologize. First of all, let me just start by thanking members of the review committee for your service, for your time, your efforts, your expertise. We're extremely grateful for it. Assistant Secretary Newland and I are joining you specifically on the topic of revisions to the NAGPRA implementing regulations, and you know the proposed revisions, when they're released to these regulations, are really long overdue. The Secretary is committed to finalizing and implementing effective revisions to the regulations, and we, Bryan and I, as the Assistant Secretaries, have been delegated the responsibility for the NAGPRA regulation revisions. And so we began that process in July. We initiated a consultation process on the regulations with, of course, Indian tribes, Native Hawaiians, and of course you, the review committee. And so we're here to answer any questions and also to just communicate our commitment to moving effective regulation revisions forward. So with that, Melanie, I'll turn it back to you.
Thank you. Assistant Secretary Newland.
Hi, Miigwech, thank you, Melanie, and good afternoon, everybody, or good morning, where I am here in the Pacific Northwest. My name's Bryan Newland. I serve as Assistant Secretary for Indian Affairs here at the Department of the Interior. Prior to this job, I served as tribal chairperson for my tribe, the Bay Mills Indian community in northern Michigan. I am really proud to be part of the team here at the Department of the Interior and proud of the team that is working on these regulations. As Assistant Secretary Estenoz noted, this reform is long overdue. It's been in the works for more than a decade, and it's something that Secretary Holland and the leadership at the Department of the Interior is committed to. We more than a year ago, had these conversations within the department and then went out for extensive tribal consultation last summer. We extended the comment period on that consultation at the request of tribes and took those comments back in-house here and worked to advance this reform. I want to thank the NAGPRA committee members who have dedicated, you've all dedicated much of your time and your energy to improving our NAGPRA program and to this work. And we are looking forward to continuing our work with you on this effort. I appreciate the letter of outreach from the NAGPRA committee and look forward to continued conversations and input from the committee as we move forward. And I also, again, just want to take an opportunity to thank you, Melanie, and our team here at the department who's worked hard on this, tribal leaders and historic preservation officers from across Indian country and committee members who've served the public, served Indian country and trying to make this program better. And I'm really grateful for everybody's service and trying to fulfill the intent and the spirit of NAGPRA. So with that, thank you for sharing your time with me today, for having me with you, and I look forward to the discussion.
Thank you both. Mr. Chair, do you or the committee have any discussion with the assistant secretaries?
Yes, I think we do. And then let me add the thanks of the review committee to Assistant Secretaries Estenoz and Assistant Secretary Newland for finding the time on what I'm sure are very, very busy schedules to meet with us. It's a relatively rare, I think, opportunity that the committee has in a meeting context to actually hear from this level of senior leadership in the department, and we appreciate you taking the time to do that. I'm going to ask if other members of the committee have questions that they'd like to start off with in this discussion. Oh, come on, I know you have questions. Well, okay, let me start then, and this is kind of a specific question, so you can wave it off if you don't have your detailed notes about what's been going on and back and forth on the drafting of the draft proposed regulations. But if you can envision this, as you know, this committee has been working with a version of the draft from July, as Assistant Secretary Newland noted, and we expect there have been changes since then to the text. We've gone back and forth with Madam DFO and the National NAGPRA advisors on access to that information. So I understand that we can't get a copy, and I know enough of the way in which regulations are put together to understand why that is. But are there some sections, let's say, of the draft proposed regulations that have not substantially changed from the July 2020 version to what the current version is, the version that's been provided to OMB and that is under review there? Or are there, and I ask that question because we basically today and in about a week from today have that much time to try to focus on coming up with recommendations for the department, for the secretary, for the assistant secretaries. And if there are ways that we could concentrate on those sections that haven't changed, where the text is virtually the same between the July 2020 and the current version, it might save us some time and give us an opportunity to provide more directly useful comments. Could you maybe address that particular question again? I know it's pretty specific, but maybe you can give us a little guidance there that would be helpful.
Well, of the two of us, Bryan is the attorney, so perhaps I'll let him answer and then I'll follow up. But Bryan, do you want to offer up a response?
Sure.
First?
Sure. And thanks, Frank, for that. We certainly are not trying to. It's not our intent to frustrate the committee's efforts. I really want to make sure that this is a collaborative process between everybody involved, including Indian country as well. And so I don't have the draft, the most recent draft in front of me. To tell you, I know that there were, as we go through tribal consultation, we incorporate tribal feedback, and it's not a perfunctory process, so there were substantive changes made after that consultation. I do want to add, though, that there's often a perception that once a rule is proposed, that's a door slamming shut rather than opening up. And it's our intent to continue not only the public comment phase, but the tribal consultation phase and our collaborative work. And so it's not, it is not as though the proposal of the rule is going to be the end of this discourse between all of us. And I suppose I should stop there, but that's my best answer for you today.
And I'll just add to it. I agree with everything that Bryan has said. I'd also encourage you to, we did this with tribes too, when we initiated consultation. We provided a list of areas that we were hoping to get their feedback on. And, if those either similar kind of discussion questions or areas of focus have been provided to the committee, then I would recommend that rather than focusing on sort of the draft as it stands today, that you approach it the way we ask tribes to approach it, which is to give us your thoughts on the questions might be different, but what refinements, whatever those discussion questions that have been provided, which I feel confident that they were, that's where I would focus the committee's work for the next couple of weeks.
Thank you very much. That and particularly that reference to the document, Madam DFO. Given the amount of different sets of discussion papers that we had when the tribal consultation was going on, can you put your fingers on that particular list and maybe identify which of the documents we should be looking at for for taking up this suggestion about what the assistant secretaries think would be most useful.
Yes, I believe that the best document for that is that July overview, the 4-page document.
Okay.
And a few weeks ago, I shared that again with the committee and highlighted some specific points in there, that 5 points in particular that I thought might be good to focus on. So
Okay.
that's what I had shared with the assistant secretaries, that I had shared that with you all. So that's probably the reference.
Okay. Okay, great. Thank you very much. And thanks to the assistant secretaries for those candid remarks. I'm sure we all appreciate them. Other members of the review committee, how about part of the discussion here, questions you might have? John, go ahead. You have your hand up.
Yes, just a clarifying question, and thank you, assistant secretaries, for joining us here today. We greatly appreciate it. And I know as a tribal citizen, I appreciate you taking the time to visit with the committee. But this is just a follow-up question, maybe a follow-up question for Frank or Melanie. So Frank, were you asking the previous there was a statement about that during the consultation process of the tribes that they had a series of areas that the Interior was interested in. Was that a follow-up question to that?
Yes.
Yes, and that I had a question to that too. So if there were these certain areas that the Interior was interested in this comprehensive process while we're going through it, I mean, I had an interest, there that would help us narrow down that process if there were certain topics that were put before the tribe. So that's my question right now. I probably have a few more, but I was just asking that as a clarifying question. So thank you.
Thank you, John, and I'll go to Melanie, but we did put forward very broad questions. How can the rules do a better job of helping you repatriate cultural and human artifacts? I mean, very broad questions, and Melanie, I don't have them at my fingertips because this was many months ago, but Melanie, and I don't know what the protocols or rules are for sharing or how much that is public, but because we're in a formal rulemaking process, but perhaps you can comment.
Certainly. As the committee knows, the PowerPoint presentations from those tribal consultations are available. And as Assistant Secretary Estenoz said, the broad questions that we've been talking about, does the revision simplify and improve the regulatory process? Does it resolve what are burdensome or complicated requirements? Does the draft clarify timelines? Those are the broad questions that we asked during tribal consultation, and they're the same ones that we've been discussing here. I think we've all talked about whether the regulatory process is shifting the burden from Indian tribes and NHOs to initiate the process to museums and federal agencies to initiate. So those are the kinds of broad questions that we had discussed with tribes during consultation, and that we would appreciate the committee's input on.
And
Huh?
again, just to follow up. So I'm assuming one of those broad topics or broad questions might have had to do with the cultural affiliation question then put before tribes, broader in the sense of how cultural affiliation is determined, but also, and as you're probably aware, this has come up in numerous times in our meetings, and from what I can gather from tribes, but also, like I said, certainly with the review committee as well, on the terminology of the geographically affiliated sort of question. So I'm assuming that was something that was of great interest or fell somewhere in the umbrella of interest for the Interior during these questions before the tribes.
Well, here's what I would say, John. The answer is yes. I mean, for the consultation sessions, and I attended most of them. I mean, there was a tremendous amount of input on these topics. But and I would say the same thing to the committee, which is that look, here's what we're particularly interested in, but we want all of your feedback. This is what we said to the tribes. We want all of your feedback, and we want sometimes that feedback comes in the expression simply of a frustration. Let me give you an anecdote of what happened in my situation or in my personal experience or with my tribe. And then that, that's input. So whatever input the committee, I mean, I think we're asking we're trying to be helpful in focusing, into areas of specificity, but, and by no means are we closing our ears to whatever feedback the committee, for example, would want to provide us. Bryan, have I misspoken there in any way? Okay.
And I want to just speak to emphasize, not to mansplain. We don't want to come from our positions in the federal government and tell people these are the narrow areas in which you can engage with us. We often ask in the context of tribal consultation, for example, here are framing questions. Here's where we're unsettled or are having discussions and could use your feedback. But again, as Assistant Secretary Estenoz said, we know folks are often thinking about things that we're not, and we want to hear that too.
Thanks. Thanks to both the Assistant Secretaries and John for that discussion. John, did you get your questions answered?
Yes, if I have any more, I'll chime back in. Thanks.
I'll trust that you will. Thank you. Tim, you have your hand up. Go ahead, please. You're on mute, I think, Tim.
There we go.
There you go.
I want to thank both of the Assistant Secretaries for appearing before the committee. Having worked with the committee long before when I was a federal employee in previous iterations, it's unusual that we get political appointees to talk to committee members. So I really want to thank you for taking the time to do this. I guess my question is actually pretty specific. The draft proposed that we've been reviewing has a lot of different changes on a lot of different things. And I know that the tribes have commented on many of them. One in particular included some revisions of how national scientific and museum organizations were going to be defined in the regulations. And I noticed that in the Federal Register notice that was published a week or so ago, soliciting 3 new members for this committee, some of those changes that were in the draft appear to already have been adopted. And it sort of gives the impression that the department has already made up its mind on some of these changes without going through the proposed rule or the notice and comment rulemaking period. So I just sort of wanted to point that out.
Well, thank you very much. And I'm sorry that is the impression that has been left. I can assure you that there's no pre-decisional action on our part. We fully anticipate taking the full range of public comment and doing our best to publish a rule that reflects as much of that those comments as we can.
If I can follow up, I don't think that this is an issue about what the definition will be in the regulations. The notice soliciting comment is an actual action you've already taken. And it's already adopted this narrower definition that's in the draft proposal. So it's an action that's already happening, where that language has already been adopted without going through notice and comment rulemaking.
Thanks.
Provide a little clarification, just for background. The language in the notice that went out recently isn't different from language that's been used in prior years and for prior notices. We don't necessarily use the exact definition in the language that appears in the regulation. It sometimes depends on the nature of the notice. The notice in no way has an impact on the definition as a defined regulation, so we can't have a narrowing effect on who fits the definition or who is applicable. But this is an area we're looking to be more consistent, and one of the changes we're proposing is to the regulations to achieve that consistency. Melanie noted something for me on the side to correct my point, that it's not that the the language that we've used is the same over time, but we've used different language over time in the notices, again, because it doesn't necessarily track the definition. But that is something we could improve probably in the future, and again, has no impact on the actual regulatory definition, which is what defines what these organizations are.
But it does have an impact on the solicitation that is in play now.
Brady, do you want to comment on that?
There might be some confusion that we can address separately, but it doesn't have a legal implication. It doesn't limit anybody any more narrowly than the definition that it sits in the current regulation.
Okay. Kim, do you have a follow-up or any other?
That's good, thanks.
Okay, thank you. I want to see any other review committee members who would like to have a particular question or topic with the assistant secretaries. I do have one other myself, but if anyone else does, I'll let them take the time first.
Just to note that assistant secretaries just have 2 more minutes with us.
Oh, okay. Well, Shelby was the one I was waiting for, but Shelby, no, you've heard what you need to hear.
Yes, and I would only also echo the other review committee members to thank the assistant secretaries for joining us today. Really appreciate your providing the input that you did and assisting us as we move forward as well in putting our recommendations and comments together. Thank you so much.
Thank you, Shelby.
Thank you, Shelby. Okay, then let me ask this, which is not specifically a regulation question, except that the regulations will have a substantial effect on this, and that is that, as I think everybody is aware, the funding for carrying out NAGPRA activities to ensure the proper and the quickest possible repatriation of appropriate remains and other objects is continually brought up as a challenge. It's brought up as a challenge among the agencies, which the assistant secretaries are most able to have an effect upon, perhaps. It's brought up by museums, it's brought up by tribes. And we're trying to improve, everybody wants to improve the process. To some extent, that means, I think, speeding up the process. I think that's one of the complaints that exists. But the process takes a long time. There's a lot of information. There's an awful lot of consultation. And from my experience in working for large organizations, including public agencies, in maintaining communications is a difficult, time-consuming, at times stressful activity. So the specific question I have for the assistant secretaries on this is, as you and others at the senior leadership level within the department are focused on trying to improve the implementation of the Act, are you also beginning to plan for increases in, for example, the NAGPRA grants program, which can reach museums and tribes and assist them in meeting the new requirements, the additional requirements, or just maintaining and trying to continue with the current set of steps that need to be gone through? Are you looking at increasing the actual budgets for the base budgets for the agencies? Because there are several agencies within the Department of the Interior that are responsible for NAGPRA, not only within Interior. There's a Forest Service in agriculture, there's the Corps of Engineers at Defense, there's the TVA, and even beyond those major organizations. Is this a matter of discussion in looking at, for example, planning for the budget for 2023, 2024, 2025, which is probably what you're looking at these days? I'll leave it there.
So what I'll say, I think it's an excellent question, and it reflects, I think your understanding of how this sort of thing works, that if an agency, doesn't matter what the rules say, if the agency doesn't have the resources to implement it effectively, it won't be implemented effectively. And we understand that completely. I have a very recent example myself in my portfolio, the Land and Water Conservation Fund, which was recently fully funded forever and ever. And we are in the process now of right-sizing the administration of that program. And I think that to the extent that our rulemaking process produces changes that then require an administrative response to effectively implement those changes, we absolutely will promote those and pursue those changes and support them. And whether, if that means budget, it could mean a lot of things, right? It certainly could have budget implications. It could have staffing implications. It could have protocol implications. There are all kinds of programmatic implementation details that would need to be thought through potentially. So the understanding that is a work stream is there, and I'm sure Melanie and her team are already imagining all of the things that we will need to be thinking through. Our priority is to get through this rulemaking process so that we understand exactly what the program is that we're going to be implementing. So I really appreciate the question very much.
Thank you. Assistant Secretary Newland, do you have anything you want to add to that? That's a very reasonable answer.
Just that we always want to try to, put our money where our mouth is, but we want to make sure we get the policy right, and we've got limited time to do that, and then plan for success afterwards. And I just want to add something I think everybody on the committee is aware of, but it just bears repeating sometimes, is that as with lawmaking, rulemaking is can be a frustrating and messy process. And I've gone through this several times at the department myself, actually with our friend Stephen Simpson here. And it takes a long time, even when everybody's committed. And so what's really important is that we have a clear statement of purpose and of values from the department's leadership, which we have from Secretary Holland, and that we work collaboratively, but make sure that we don't allow the perfect to become the enemy of the good here. And this is an effort that we set off the top has been a long time coming. And I know that there may be frustrations during this process, but I think everybody who's listening in, and who's participated to date shares some of these goals and objectives, and that's our focus and our commitment. So I want to thank the committee for having us here today.
We thank you as well. I would like to just add to that there have been a lot of successes as well in implementing NAGPRA. Has it been complete success? No. Was it originally envisioned that it would immediately happen and that it would be complete success in the short term? Realistically, I don't think so. In part because in the statute, the actual text, there is leeway, there is an expectation, I would say, that working on issues related to culturally unidentifiable, for example, we're going to require additional regulatory approaches, and I think we're at that point. We've been at that point for a while. I understand that, and I get the frustration.
I do.
But we
sorry
do. Yes, just
sorry to interrupt, but the assistant secretaries have graciously given us 6 extra of their minutes. I know each one is important, so
okay.
We do appreciate both of you being here with us today and making time in your schedules.
And the review committee definitely does. Thank you very much, and we look forward to working together in moving forward on this important matter. Thank you.
We're very grateful. Thank you all very much. Have a wonderful day. Bye-bye.
You too.
Mr. Chair, would you like to move forward to the next agenda item?
Unless the other members of the committee have any comment that they'd like to make based on the discussion that we just had. Feel free to chime in on that if you'd like. Otherwise, we can move forward. Tim, go ahead.
Melanie, I just want to thank you for your efforts to get the two of them here. Thank you very much.
And Shelby.
Melanie, I would also like to thank you for arranging for the assistant secretaries to join us. It was very helpful, I think, for all of us to hear from them today and to have a better understanding of how the process is moving forward. So appreciate it and thank you so much.
Indeed. Thank you. Thank you, Melanie. I should say, Melanie asked me to send a letter inviting them, but I think she had already done the basic footwork to make sure that when the letter was received, it would be accepted. So I appreciate that very much. Thank you.
Certainly. The next item on the agenda is public comment. Every meeting of the review committee includes time for public comment as required under FACA. If you are interested in providing a public comment during this meeting or at future meetings, you may raise your hand using Zoom or make a chat, use the chat feature to indicate your interest in making a public comment. The review committee can also accept written comment. And we have currently have two requests for public comment. Those have included written comment ahead of the meeting. The first public comment, I'll go ahead and say the two are from the first from the Tribal Legal Development Clinic of the UCLA Law School. And the second public comment, it's from the Authentic Tribal Art Dealers Association. So I would first like to turn to Lauren. I think you can access your video and audio now, as well as Peyton and Caitlin, if you would like to provide your comment at this time.
Hi, thank you so much for having us. My name is Lauren Van Schilfgaard, member of Cochise Pueblo and the San Manuel Band of Mission Indians, director of the Tribal Legal Development Clinic at the UCLA School of Law. As a project for this semester, we were tasked with looking at the proposed regulations through the lens of California's NAGPRA and potential implications that proposed implications might have on CalNAGPRA and vice versa. And so I'm honored to turn it over to our two exceptional students who did the research this summer to share and hopefully provide some useful guidance to the review committee, as well as to tribes and to everyone engaged in these proposed regulations in this important work. I'm going to turn it over to Peyton Moody and Caitlin Walker.
Hello, everyone. Thank you for having us. Just a quick moment while we get set up here.
All right, so hi, I'm Caitlin Walker, and Payne Moody and I will be presenting on behalf of UCLA Law's Tribal Legal Development Clinic, and we'll be talking about NAGPRA's proposed regulations and their relationship to CalNAGPRA. So our project goals were to provide the Native American Heritage Commission and California tribes with a comprehensive analysis of how the proposed federal regulations likely interact with and impact CalNAGPRA. And in this process, we relied on tribal comments, interviews with NAGPRA practitioners, and our own analyses of various statutes and regulations related to NAGPRA and CalNAGPRA.
So just to give a quick overview of NAGPRA, the California Native American Graves Protection and Repatriation Act is a domesticated California statute that was enacted in 2001, in large part to address some of the shortcomings of NAGPRA to cater to the specific concerns of California tribes. NAGPRA differs from NAGPRA in a few specific ways. First, it accommodates non-federally recognized tribes within the statute. Then it also strengthens tribal consultation standards and deference to traditional tribal knowledge.
So our main findings were that NAGPRA would benefit from using NAGPRA as a model in tribal consultation and tribal deference, and that the proposed regulations' new recognition of joint claims offers no new way to accommodate non-federally recognized tribes in NAGPRA, which is especially helpful for non-federally recognized tribes in California. And if overlap exists between NAGPRA and NAGPRA, the federal regulations should acknowledge the existence of NAGPRA and defer to those higher standards when possible.
So as Caitlin mentioned, NAGPRA could serve as a model in regards to tribal consultation. First, NAGPRA has a more robust definition of consultation. It's included on the first bullet point on the slide. But specifically, NAGPRA stresses the need for museums and museums and agencies to proactively engage in consultation as soon as possible. And it furthermore centers tribal consultation in areas like creating or updating museum inventories, obtaining tribal consent while finalizing inventories, and establishing duty of care for handling of objects. And furthermore, NAGPRA includes recognition of the need for confidentiality within consultation.
And another area of NAGPRA that is particularly helpful is the deference to tribal knowledge. So throughout the statute in NAGPRA, it states things like deference shall be provided to tribal traditional knowledge. And this is particularly helpful in evidentiary standards related to cultural affiliation. So NAGPRA has a standard of preponderance of the evidence that's defined in regular terms of more likely than not, but it also includes the phrase that tribal traditional knowledge alone may be sufficient to meet this standard, and that if there is conflicting evidence, tribal traditional knowledge shall be provided deference.
With regards to tribal inclusion, NAGPRA can also serve as a model. So NAGPRA in the proposed regulations definition of Indian tribe is contingent on federal recognition status, which excludes many non-federally recognized California tribes. In contrast, NAGPRA has a broader definition of California Indian tribe to include either federally recognized tribes or whether the tribe is located within California and is on the contact list maintained by the Native American Heritage Commission. And notably, this contact list contains many non-federally recognized tribes. We found that the proposed regulations definition of Indian tribe will likely have little impact on the inclusion of non-federally recognized tribes under NAGPRA, given that NAGPRA already has infrastructure set up to incorporate these tribes. However, we believe that the proposed regulations should acknowledge the existence of NAGPRA and comparable state statutes that provide for non-federally recognized tribes as NAGPRA claimants. And furthermore, we found that the new recognition of joint claims in the proposed regulations was a great step up and has the potential to indirectly accommodate non-federally recognized tribes via joint claims with either other federally recognized tribes or repatriation coalitions.
And we also recommend that the proposed regulations recognize NAGPRA and that the proposed regulation should state that if there is a dispute between the statutes, parties should defer to the standard that is most favorable to tribes.
Again, thank you so much for allowing us to be here and to speak with you, and we are happy to do our best to answer any questions you might have.
Thank you.
Thanks very much for your clear presentation and suggestions. Review committee members, do you have some comments or questions you'd like to ask? John, go ahead.
Yes, thank you, Frank. I want to thank you both for your presentation today. I'll start with one question I have. I had particularly about your position on tribal deference. I guess my question is certainly be certainly in support of that. But have you had any, certainly during the development of this of the process and these definitions, have you had any concern or pushback on those positions by entities, research institutions, universities, museums there, particularly where you're located? Have they had, I would assume some might have some strong positions on that, or concerns about that? Have you received any comments to that?
Caitlin or Peyton, do you want to try to respond?
I think from our position, we were trying to focus on what it was that the tribal comments were saying, and specifically what California tribes had wanted. We had talked to some people involved at the university or at UCLA's aspects of tribal collection, and they didn't seem to have problems with it, but I'm sure there would be pushback on something like that, or there could be.
Yeah, and just to add in on that, our findings were that there have been those concerns thus far. However, we found that in disputes, there are already different forms of knowledge that are being offered. So specifically, the statutes reference traditional tribal knowledge, including oral histories. And we found that elevating those in the evidentiary sense would basically center knowledge that tribes have. So we recognize those concerns. However, we think it's important to uplift the knowledge that comes from within tribes about their own cultural heritage and sacred ancestors and objects.
And just a quick follow-up to that. So has any of what's been proposed or what's presented, has any part of that been put into practice as of yet?
Hi, this is Lauren. I can at least answer that in regards to the UCOP policy. So as part of the NAGPRA, the UC system, the University of California, have their own policies that have incorporated this, which goes to your point, the extent to which entities, specifically universities, might be in opposition. So this has always been a part of NAGPRA and has always been in operation. That being said, UCOP, the policies for the University of California, have just updated their policies as of December of 2021. So it's pretty fresh, but those updated policies were in response to institutional opposition. So I think it's to be determined the extent to which that is going to be successful. But I think it's important to note that NAGPRA was, in its first iteration, written with centering this tribal deference. And so, the little data that we have, yeah, I think it's working. But NAGPRA is also operating in the same universe as NAGPRA. So a lot of tribes have encountered this interesting strategy where the tribes and institutions are strategizing whether or not they want to utilize the NAGPRA framework or the NAGPRA framework. And so that's been interesting as entities navigate that.
Okay. Thank you. Thank you for that additional clarification. John, did you get the answer you were looking for? And
yes, I think I'm good for now.
Okay, thank you.
Thank you, Frank.
Sure. Other committee members, you have questions or comments? Tim, go ahead.
Just a point of clarification with Lauren. My understanding is that the revised, updated inventories and summaries deadline has already passed. Is that not correct?
I think so, but I can't answer with certainty. We can look into that though, to be sure.
Thank you.
Thanks, Tim. Thank you, Lauren. I have a question about the non-federally recognized tribe, that category. You've mentioned a couple times that it's based on a list compiled by the statewide Native American, I'm not sure, the commission. What are the rules for an organization to be formally recognized as a non-federally recognized tribe in California? Because, I mean, that is an issue in other parts of the, well, throughout the country, really.
I welcome Peyton and Caitlin's contributions to this. I think you nailed it on the head in your phrasing. It's not a formal process as of yet. My understanding is that the California's Native American Heritage Commission has compiled this list firstly for the purposes of cultural resource protection pursuant to California's Environmental Quality Act, or AB 52, which amended CEQA. And so they have an internal process. I don't believe, but I haven't looked at this squarely, that process is either formal or public yet. But because that list has sort of grown legs and has become utilized formally for NAGPRA, but informally for other purposes of tribal consultation within the state of California, it's becoming de facto formalized. And so, I think it's important to consider that, but I also think it's important to appreciate the historical context of California, the numerous number of tribes that were never had formal federal recognition, as well as the numerous tribes that were terminated. And so, part of accommodating that history is this list. And I think California is now navigating how to do that with a formal process, but also avoiding the bureaucracy that has denied tribes access for so long.
Yes, thank you. I'm aware of the historical, early tragedy in California regarding tribal entities and the lack of recognition that occurred more than 100 years ago at this point. But this is an issue, I raise it because it is an issue within the other states as well. And that, in part at least, is because the formal recognition process at the federal level, which is very detailed and time consuming and all of that, does actually have a lot of results. They can be substantial economic results and political results as well. And I think, I've known situations where recognized tribes would oppose certain other groups attaining formal recognition because they don't feel that in fact they meet the criteria and the rules, if you will, for that designation. And so I think it's important to try to understand the different approach that's being taken in California, where you say that it is an evolving a way that may have began by trying to identify individuals who could be used as consultants and observers for public works projects to ensure that Native Californian remains or sites weren't overlooked by subdivision development, for example, something like that. And that's, I think I understood correctly that's how this list got started, at least. And now, as you say, it's become useful or it's being used for other purposes as well.
Yeah, just a small response. I lost my train of thought, apologies. Only that the Native American Heritage Commission in California operates akin, I believe, to this committee. And so there is, a formal entity that is engaging in reviews of some of those claims. But I think I also want to highlight Peyton and Caitlin's recommendation for sort of threading the needle. The list in California is certainly not without controversy, is highly politicized in the different put forth was, rather than adopting like CalNAGPRA's, full, incorporation of California tribes, which CalNAGPRA does, but include these non-recognized tribes via the joint claims route, which provides an opportunity for non-recognized tribes to participate, but sort of with a federally recognized tribe liaison that is, both culturally and politically endorsing their claim and sort of providing a foot in the door to facilitate that repatriation process.
And I think we have examples of that at the federal level.
Yeah. Which show that it can work and that tribes are collaborating in really meaningful and useful ways.
Thank you. Other review committee members, any further questions or comments? John, go ahead.
Yes, thank you. And this is probably more of a comment than a question. And I'll circle back to the clarification about the tribal deference. And I'm saying, I guess it's an observation, I'm saying this pretty much in support of that, because you mentioned particularly NAGPRA, the NAGPRA law, the NAGPRA regulations as a part of your process, and particularly the comment from just a few minutes ago that, in particular, that tribal deference was one of the drivers behind of what you've worked on or what you presented here today. As you know, we're certainly going through. The review committee is certainly going through the process of looking over the current proposed changes to the regulations. But something I did note as a part of your presentation, something that has certainly come into my mind is we're going through our own review of the proposed regulations. I think it's interesting that we're almost going through a process to codify tribes' positions in terms of whether we're talking about the overall regulations or cultural affiliation and things like, that's being presented. So I want to commend you on that. But my also comment to that, and I'm sure that you're certainly aware of that, is, and I certainly don't like to say this, but to me, it's a strange position that we have to put something in there that we're trying to come up with, I would say, some sort of solutions, again, to codify and support tribes' positions in whether it be for cultural affiliation or those claims. And to me, really, I mean, it's where certain entities may take on, and I think we're and perhaps your project is working on this as well, is that where certain entities that we're having to work to try to codify this because those entities may be dismissive or, unfortunately, or very paternal towards tribes' positions in there, even in this day and age. And so again, I think it's interesting that we're having to come up with some sort of, putting those positions in there or reaffirming that when it should be self-evident that these are the community, the very descendant communities are the ones that are impacted by that. So I want to again thank you for your presentation, and certainly for as you move forward with that, they're certainly in the state of California. So thank you for that. Thank you for that presentation and your comments once again.
Thank you, John.
I would just like to add that I have been very impressed by what Peyton and Caitlin and Lauren have provided just in a very brief summary here. And the National NAGPRA program would very much like to hold a longer discussion around this question of the intersections of NAGPRA and NAGPRA. And so Lauren and I are still working on some scheduling for that. But once we do, we'll be sure to post that on our events page so that anyone who's interested in this topic can attend and have more discussion around this.
Oh, good. Thank you, Madam DFO. I think we could probably have more discussion here, but I'm afraid we've extended our time on your particular topic, but we really do appreciate the time you've invested so far in the project, and hope that as you move forward with it, that there'll be successes and uses of what you've pulled together. Any other comments from review committee members? If not, I think we have another presentation, Madam DFO, I think, that we should probably get onto. Again, thank you very much, the three of you, for
Thank you.
your information.
Thank you so much for having us, and special thanks to Peyton and Caitlin for all of their hard work this semester.
You're here. Thank you.
Thank you. The next public comment is from Kate Fitzgibbons, the Authentic Tribal Art Dealers Association. Kate, you're still on mute.
Okay, very good. Greetings to you all. My name is Kate Fitzgibbon. Thank you, Melanie, for introducing me, and I'm here representing the Authentic Tribal Art Dealers Association, ATADA. I would also like to express my appreciation for your contribution as public servants today. As a former member of the Cultural Property Advisory Committee to the President of the Department of State, I know very well how hard the work is that you are doing and the dedication that it requires. I hope that you have all seen the memo that we submitted. The information that I'm presenting today is relevant to the NAGPRA committee, not only because your expertise will be drawn upon if the STOP Act is passed in order to help in implementing it. I also ask, though, that you consider the potential to broaden the scope of tribal claims under STOP when there are changes to NAGPRA's determination of cultural affiliation to a geographical basis, particularly with regard to prehistoric and pre-contact materials. So to get to the specifics, ATADA strongly supports the return of stolen communal objects and items in current religious use. ATADA doesn't just say this. Our bylaws prohibit our members from selling sacred items. And since 2016, our voluntary returns program has brought back almost 400 truly sacred objects, many of them held for generations in private collections, directly to tribes at no cost to them. With the help of tribal elders, we have worked hard to educate collectors and the public, and the voluntary returns are growing every year. ATADA's objections to the STOP Act are not about money. They are common sense. They are about making good laws and not bad ones. The STOP Act, as it's now written, will harm Native communities, not help to bring sacred items home to them. Its requirements are so burdensome that it will result in a de facto export ban of perfectly legal objects, and it will harm Native artisans, for example, in my home in Santa Fe, where the Indian market is celebrating its 100th year. Let me quickly outline some of the problems, as I want to stay within the time limits. STOP is incredibly overbroad. It covers objects down to $1 or less in value and any age, when there is no evidence for sales of such stolen items, which is like using a sledgehammer to crack a nut. The US already has the strongest laws in the world to prevent the sale of stolen items. If an object is reported stolen, it cannot be sold, and good title does not pass, ever. There is already a 10-year penalty for false statements to US Customs that would encompass stolen items, and a stolen item is already illegal to export under NAGPRA's and ARPA's trafficking provisions. STOP ignores the existing prohibitions in the law to impose a completely new secret system to review export applications. And without clear identification of which objects are sacred and which are not, there is not adequate notice to the public, and virtually any item would have to be submitted for an export permit. Commercial items and new items are not excluded from STOP. They're just mostly excluded, which means that anything could require an export permit, and it would behoove anyone, including a museum that is exporting items for temporary export for an exhibition overseas, to seek a permit under those circumstances. STOP has serious constitutional problems. It fails to meet the requirement to give owners of objects denied export a fair hearing. It denies access to defendants of opposing evidence, even through a Freedom of Information Act request. That is, if something is seized and it is disputed, or if someone is charged with exporting something without a permit and it is seized, there is no way to obtain the evidence under the STOP Act that would enable someone to argue that their rights that this is not correct, and to establish a defense. It would grant tribal governments extraterritorial jurisdiction to infringe on rights of free expression of artists that are working outside of pueblos and tribal territory, which is where most Native American artists are working. STOP imposes barriers on the export of artistic, religious, and historic objects that has never before existed in the US. We do not restrict the export of anything, unlike many countries that have very comprehensive export bans of everything from postage stamps to prints. Export prohibitions that are based on the use of certain forms or imagery would violate First Amendment rights of free expression. And I think we have all seen situations in which tribes have objected to the sale of certain objects simply on the basis of the inclusion of certain designs on them by tribal artists. I personally have dealt with this through Senator Udall's office. Export prohibitions based on religion appear to me to be a violation of the Establishment Clause. So STOP finally would distribute seized objects to Hawaiian entities that are not governments and not sovereign. This could open up issues that Native Hawaiian communities have tried to avoid ever since the Supreme Court's ruling in Rice v. Cayetano in 1999. It's a real can of worms. And what would be gained? The genesis of the STOP legislation was French inaction on a tribal request to stop an auction and repatriate a ceremonial shield from Acoma Pueblo. ATADA members actually helped to bring that shield home, but I didn't ever read about that in the newspaper. We worked hard with Acoma representatives two Congresses ago to achieve legislation that we agreed on and they agreed on, that would have met the important and worthy goals of the STOP Act without the inclusion of its most burdensome and restrictive elements. I urge the NAGPRA committee to think hard about whether the United States should dedicate the limited resources that it provides for securing Native American heritage to tribes to such risky and polarizing and constitutionally flawed legislation. NAGPRA will be part of administering the STOP Act in whatever form this legislation takes. Its expertise will be needed. We hope that the NAGPRA committee will work now to address what is seriously wrong with the STOP Act and help all of us to move forward in a positive way to secure heritage for tribes. Thank you very much, and I'm happy to answer any questions.
Okay, thank you very much for that clear and detailed presentation. Review committee members, do we have some questions or discussion points? Well, I do have one. You've explained a number of the problems that you see in the way that the law is currently drafted. Why, just taking the other perspective, why do a number of people think that this is needed, that these activities or these controls are required? Can you fill us in a little bit there as well?
You know, I would not take the liberty of speaking for the tribes.
Is it and it's tribal organizations that are mainly pushing the statute or have sort of mobilized their political representatives to do so? Is that?
It's a few tribal organizations that have done so. we have not seen, except for more generalized support, from tribes outside of the southwestern area, but it has been primarily tribes in my understanding. And we try to attend conferences, AIA, conferences and so on, in order to hear from the tribes and to learn from that. And that's actually how we began our voluntary returns program, was at such a meeting. Tribes and tribal members said, well, you say you agree with us that this is wrong, that these sacred items are being traded, and which is in fact one reason why I think there was this initial flurry that has not been repeated of multiple auction houses in France selling items, was that US dealers are much less willing to trade in items that we clearly recognize as sacred. And some tribal members said to us, why don't you do something about it? And we thought, yes, we should. And that's why we started the voluntary returns program, which has brought back, several Zuni war gods, dozens and dozens of masks to multiple tribes, well over 350 objects now, almost 400. And this is increasing. And our work is purely based on the communications that we get from the tribes. We try to respect that. I have actually gone on some of these 5-hour drives to return items, but I've never seen them, because for those tribal materials, it was considered inappropriate for a woman to see or handle them. We try to respect that, and we follow their directions. We don't determine what is sacred. We ask them. We gather together materials that we understand from ethnographic work. We have members that have are native or are part native, and who have spent 50 years working in this field. And so they have some understanding of what's out there in private collections, which are not ordinarily subject to NAGPRA. Because we wanted to go beyond that and to contact people and bring those in. But one of the issues we have is that sometimes things have been so long out of tribal hands that the traditions with respect to those objects have been lost. And the elders have been very frank to tell us that that is the case. So that's one of the things we do. In terms of why tribes would seek to expand the scope of the existing restrictions on sending something that's stolen out of the country, they believe, I think erroneously, that there is a far larger market outside the country than there actually is. Just a review of the 2021 ArtFod report, which is the main data collection space for tribal and ethnographic art around the world. Of the 10 most valuable items that were sold in 2021, 4 of them came from Canada, or I'm sorry, 3 of them came from Canada, 4 of them were textiles, blankets and wrappings that are would not ordinarily be subject to tribal claims. We're not talking about millions of dollars here. This is the tribal and ethnographic art market is one of the smallest art markets in the world. So we don't see the evidence. We really think this is using a sledgehammer to crack a nut, and that there are resources available, that the scope of, we don't have a problem with in terms of stopping stolen items. We do have a problem when it goes far beyond that. And when when there are claims that supersede existing protections under US law, and that when there's already a 10-year penalty for exporting a stolen item in the United States. And things that were forgotten. I'm sorry, I went on a long time, but.
No, thank you. We appreciate that, the concerns that you're expressing. Other committee members, you have questions or comments you'd like to make? If not, then Kate, thank you very much for your clear interesting presentation and responding to some questions, and for the written materials that you submitted. I think the takeaway maybe for us is we should, we're, as you know from the last couple of presentations we had at this meeting, we're pretty enmeshed in regulation review and recommendations for implementing NAGPRA. But as you note, the text of the draft text of the STOP Act asserts some role for the review committee, and we should be aware of that and watch what happens there, or be maybe be a little well, watch what happens there probably is a good way to leave it. So thanks very much to you and others in your organization.
Thank you very
Thanks
much.
for the voluntary program. That sounds very good.
Thank you. I would really encourage you to utilize any resources that we can offer to you, and would simply like to reiterate that we see the worthy goals that are attempted to be achieved here. We support those worthy goals. We simply want them to be expressed in a way that is effective for Americans and supportive for the tribes and supportive for all of us who share their concerns. So thank you.
Thank you. Thank you very much.
Thank you. We have one comment that came through in the chat that I would like to read, and it's in regard to non-federally recognized Indian groups. The comment is from Domonique deBeaubien, and she says that it's important for other regions of the country, as opposed to just California, especially in the Southeast, that there are standards for what a state tribe really is. We have corporate structures evolving into state tribes for 8A preference. Consulting with them is at the same table is problematic on many levels. If you remove the standard of federally recognized tribe, what prevents any group identifying as tribal from making claims under NAGPRA? Which agency is responsible for defining a tribe, and what prevents that system from being abused? So those were her comments in regard to the non-federally recognized issue. At this time, I do not see any other requests for public comment. If anyone would like to make a public comment, you can raise your hand. You could put your name into the chat and I can call on you, or you can share a written comment.
Madam DFO, I think we're finished with that. I recognize we have another opportunity at the end of this, towards the end of this meeting, so we can come back to it as well. I wanted to ask a favor of you. Can you send us an email with the chat texts? Maybe once we finish the meeting, the full text, because I think it's interesting to have these comments, and then we can incorporate those into our own notes if we can get a copy of it. So appreciate that. I think you've done that for us in the future, or in the past. Hopefully you will do it for us in the future.
Certainly. We save all the chat, so we see you.
Okay, great, thank you. And I think on our agenda, the next segment is for the discussion of revisions to the regulations, which we want to get into. I'm going to suggest we might take a 10-minute break right now. We're about an hour and a half into the meeting. I'll come back and get started at least on our discussion of topics, and then move through that part. If that sounds good to you, Madam DFO, do we want to take a pause?
Certainly. So a 10-minute break?
Yes, that seems to be our standard time frame. So hopefully everybody's used to that. Don't dilly-dally though. See you all in 10 minutes.
Are we ready to resume?
Okay, are we all back, Madam DFO?
Yes.
Thanks.
I did want to take the opportunity to note that we did hear from Honor Keeler that she is unable to attend due to
Okay, thank you for letting us know that. I had known about Barnaby's absence, but not Honor, so hopefully she'll be able to make our next meeting. Oh, both of them actually, the next meeting, so should we get started on the next section? Okay. We've had some administrative and initial discussions about trying to focus our review of the draft proposed regulations in some areas. And of course, we heard from the two assistant secretaries earlier today that they thought that this would be a good way to proceed. So from our planning of this meeting and next meeting, I took away a few topics that I thought we might start with. And these are ones that other committee members had identified. Let me just say what I would propose we do. And let me say that the way I propose we try to do this is we take about 30 minutes per topic, discuss the issues, try to come up with a statement that would be a recommendation, as specific as we can about the particular topic. And then if we don't finish it, we sort of leave that and get on to the next topic. And then on the 9th at our meeting, if the topic that we didn't finish is important enough, we come back to it. That would enable us to get maybe this afternoon, get through 3 or 4 topics, hopefully successfully. And then we can think about what other topics we want to try to deal with. Do I have any nods from my colleagues on the committee that we should try that? I think Shelby nodded. Tim says thumbs up. Okay, and John as well. Okay, well, let's try it. So the next thing then is the ones that struck me based upon our discussion about planning for the meeting and scheduling it. And I would suggest we try to do this maybe in this order. One is to go back to section 10.1, which we have actually spent probably a couple hours total talking about, and see if we can finish the comments there. And this was the one where, this is the one where we were talking about the purpose in the introductory section, the purpose, the duty of care, and then there were some other things. We actually have a text that I think Tim compiled from our discussion, or it may have been one of the other members, or maybe several members. My copy is dated March 16th, and it actually has some recommendations that we might utilize. I don't know if others can access that on your computers. It's called Draft of the Committee's Specific Recommendations Regarding the Draft Proposed NAGPRA Rule, and it's dated March 16th. And it deals with 10.1. It's about 2 pages of text. And related to that, there is a text that John and Shelby put together about duty of care. That the date on my copy is the 19th of March, and it was coming up with a different definition or description of what was meant by duty of care than is in the draft regs at this point, anyway. So that would be something that I think if we could try to deal with in the next 30 minutes, maybe we could finish it off. It was pretty close. I think Tim suggested at our planning discussion that that might be a way to get started at least. The second category that I have would suggest is that we deal with some of the definitions, in particular cultural affiliation, geographical affiliation, and acknowledged Aboriginal land, but I know there are others as well. We've had some discussion about these different terms, but I don't think we've ever actually started to say whether we think they're a good idea or a bad idea, or if we have questions about them. But that I would suggest we take on second after we hopefully resolve the 10.1 section. That one actually may take a bit longer than 30 minutes, but maybe we could start with a couple of the definitions that keep coming up in our discussions as something that we have some concerns about, and focus our time there. And then Tim had recommended, again, in our planning session, looking at the changes that would be part of the new regulations if the draft were accepted, regarding the planning around what happens when NAGPRA-related remains or items are discovered during an ongoing or investigation or something of that sort. That would be a third topic that we might try to take on this afternoon. John, you have a comment, please. Go ahead.
Yes. And while we were under the topic of, I guess you'd mentioned some of those, particularly the definition part, and kind of going back to briefly on things that we discussed in the administrative mean. I guess for those particular definitions, you mentioned cultural affiliation and geographical affiliation. I would think those fit under a broader topic or a broader recommendation that the review committee can make. And so while we've spent a lot of time contemplating certainly the content, and that's the wording, and that's important. Just a takeaway that we've had from what we received from the assistant secretaries, and I think we're looking forward to see what the newer draft is going to be. But I guess the important part of those definitions is, if we're going to discuss those, is how they fit into our, perhaps not just a definition, but how they fit into a broader sort of something that this committee could recommend. And I certainly have. I'm acknowledging my time is short on this committee, but I look forward to seeing how the process progresses. But I guess how we make a recommendation, even if we're not 100% on coming to the exact, or if it doesn't exact definitions on that, but how we can, we can fit that into
I think that's an excellent point, John, and I appreciate
recommendation.
You making that. So maybe it's not really definition so much as how is it anticipated? And this would be a question we might ask Madam DFO in her other role as manager of the National NAGPRA program. How would the geographical affiliation or any changes to cultural affiliation that are anticipated in the draft revised regs affect what gets done? So it's the process as well as the definition, John. Is that what you're?
Yes, and just based on the comments that we received from the assistant secretaries, and it seems like their conversations that they've had with tribes, even with the draft that's currently being revised, I think we're certainly of the knowledge that Interior and National NAGPRA wanted to accomplish something by making those changes. And I think that, I don't know if it's just my opinion, but there are those moving parts in there they wanted to address, particularly with the CUI question and the associated funeral objects question that they wanted to make changes to. And I think while each of us may have some sort of, an input or perhaps a misgiving, certainly about the term geographical affiliation. Really looking at to see what is looked at to be accomplished. And I'm basing that on not just our conversations, but we've received some interesting, I think, some input from not just the tribes, but from the letters that we've received. And I think that that's worth, at least with the comments we see from those organizations, but because I noted some interesting, I guess, positions within those letters that certainly could enter into this, that particular part of the conversation that I think that's worth covering. But I think, sorry to be taking so long, but I think that in order for I think it's to support a recommendation, so we don't get so lost in the weeds on, and not that it's not important, but we don't get in the weeds on those definitions, and that we can make a recommendation, or if it's not, if it's a recommendation slash opinion on that then the assistant secretaries can work, can consider into the overall review process, or taking some of the recommendations or opinions of the other review committee.
Okay. Again, I think those are good points. Thank you very much.
Thank you.
Other committee members, Tim or Shelby, you want to comment on that also, or general agreement? Okay. Yep. I think so. All right. So if we look at section 10.1, and do we have some comments that we can regard as final there? We'll take, as I said, try to, in 30 minutes or less, look at that, and then and reach a conclusion there, and then maybe based upon John's comments and the validity of that, and our trying to deal with not just definitions but process and procedures, maybe we try to pick up on cultural affiliation. How is that going to help? How would it be used? Who's responsible for what? What does it actually mean? And we'll be reviewing things that I think we've heard already, but maybe we're in a position now to actually reach some conclusions about it. And then we can, if that works, we could look at any changes to cultural affiliation. Again, what it would mean, what sort of different activities or additional activities would be required by whom, and is this a good idea or a bad idea? If we can be so specific about it. Okay, so I'm going to take that as a yes. And Tim, I wondered if you wouldn't mind maybe sort of reviewing where we are on 10.1, and maybe sort of say what you would recommend, and I think others can react to that, if that's possible. You feel up to that?
I'm actually having difficulty pulling up the document. Could we send it back out? So, or put it on the screen.
Yeah. Melanie, do you happen to have that? Okay, that'd be great. Thank you. Great. Yes, that's it. Okay. Thanks, Melanie. Tim, you want to?
I just want to note that this is the version that was sent out just before the March 21st meeting. So it does not incorporate the discussion that you had on March 21st about these issues.
Okay.
Tell you what, how about let's defer discussion of this, and I'll do the math on this. I'll integrate everything so that we have a clean document with all the comments that we've got, and then can address it quickly, I think.
At the next meeting?
at the next meeting.
Okay.
I mean, if everybody's comfortable starting with this one, that's fine too. But I think juggling between different documents is cumbersome.
Yes. Okay. Anybody have a different suggestion than that? Okay, then if we do that, then we can move right on and talk about geographical affiliation and where it fits in the process. And I would suggest we ask Madam DFO or National NAGPRA Manager to give her sense of how it fits, how it would make the process different. Well, I would have a question. As I understand it, museums and agencies that have that still have possession of NAGPRA, Native American human remains covered by NAGPRA, and other NAGPRA items would be required to expand the inventories that they've already submitted to incorporate information about geographical affiliation and see whether that reaches well, incorporate that information. And I guess then if there was a geographical affiliation with a tribe or tribes, contact those tribes or tribes and engage in consultation about repatriation of those remains to the tribe or tribes within I think a 2-year window. Is that?
Well, I would not describe it as an expansion. The act itself requires an inventory to identify cultural and geographic affiliation. That is what the purpose of an inventory is to identify cultural and geographic affiliation. In practice, that resulted in 2 lists that comprise an inventory. One of those identifying the culturally affiliated human remains and the other culturally unidentifiable. But in that culturally unidentifiable inventory, there should have been geographic origin included, geographic information. So there's I wouldn't say it's an expansion of the inventory in any way. What is being proposed in the draft text is as you say, a requirement to update inventories by conducting consultation with those tribes that have a connection to that geographic location. Again, the geographic location was already required to be identified in the inventory. So it is a matter of then consulting with tribes based on that geographic information. Yes, in the draft text, that would be done within 2 years of the effective date of the rule.
Okay, let me just ask one question about that. And this is maybe where the definition of geographical affiliation it comes to bear. There are specific kinds of information that museums or agencies that hold these remains and objects have to look at that were not specified in the original requirements of the inventory. Correct? These are drawn from the how cultural affiliation is determined for new discoveries. I believe it's the Court of Claims information, but it's also treaties, other relevant historical information, things of that sort. There's a list which I don't have my eyes on right now.
So yes, that list is currently the list that identifies Aboriginal land under the culturally unidentifiable rule. So those are the same sources that are drawn on under 1011, the culturally unidentifiable rule.
Which was implemented post the inventory, the initial inventories that museums and agencies were required to submit.
So the way the process works right now is if a tribe wants to request culturally unidentifiable human remains be returned, then they request consultation with the museum. The museum must respond within 90 days to that request. They then consult on the collection, and if the tribe is connected through the geographic location and those Aboriginal land sources, then there must be an offer for transfer of control. What the change in the draft text does is require that consultation be initiated by the museum or federal agency rather than waiting for the tribal request.
Well, except that before that, the step of actually identifying the geographical affiliation requires that the agency or the museum consult additional information about that's now identified specifically as displaying geographical affiliation. That this is information that wasn't required of the initial.
I see. So you're saying that
culturally unidentifiable.
Right. So the inventory requires identification of geographic origin, right? So a location is required if known in an inventory, the location of where the human remains were removed. That geographic information was required in the inventory under the Act.
Yes.
And so the step of associating that geographic location to a present day tribe is what consultation should result in. So under the Act and the 1995 regulations, museums were supposed to initiate consultation on their inventories with any likely culturally affiliated group based on information available, which would include the geographic information. So if what you're saying is it's not known which tribes might be connected to the geographic location, and that is the process that you're pointing to, that would be a process that would occur during consultation. In terms of identifying which tribes to consult with based on that geographic location, again, excuse me, there are lots of secondary as well as primary sources available for excuse me. For identifying which tribes should be consulted.
Okay, but what I'm suggesting to you is that that's not a process that's already happened. That is a process that museums and agencies will need to go through. And there will be questions about which sources are used or should be used, the amount of time that should be spent on making those connections. You're connecting both the objects that have been characterized as culturally unidentifiable and this geographical information. And you are also looking at the geographical information and trying to identify which tribes you should be contacting, if you were the museum or the agency. That is new work. That is not.
I would disagree. I think that was a.
Well, we may disagree, but yes, we can disagree on it.
That work was required between 1990 and 1995.
I don't think it was in many cases. I suspect it wasn't in many cases.
Well,
but
whether it was done or not is whether it was required, I think it's clearly required, that consultation. Brady?
I think another element here that I just want to add is to not forget that 1011 lays out this process already, and it sets it up in a claim form where museums are responsible for this process and for this consultation at present if they receive a request from a tribe. So the change here isn't to change up the responsibilities of the museum or to create new ones as much as it is to change how the process works so that it is less incumbent on the tribe to have to initiate the process. And instead the museum has that initial burden to reach out to the tribes and invite them to engage in that process. Tribes, of course, may choose what they want to do from there on out, but it shifts that initiation of a process that's already in existence and could theoretically, if a number of requests came in tomorrow, cover all of the remains that are there, and museums would be responsible for that process, again, as described in 1011, which passed about 10 years ago.
Well, right, but again, that was put into the regulations subsequent to the original inventories having been completed. So what I'm saying is if in the completion of the original inventories, the cultural affiliated portion of them, the agencies and museums didn't consult the kinds of sources that perhaps the National NAGPRA program envisions or the Department of the Interior envisions, but they did, some other sort of information. They would need now, if the draft were to become final, they would need to do that additional work. John, you have a question or a comment? Go ahead, please.
Yes, I'm going back
John,
to.
I'm sorry, there's just a really good clarification here. I'd like to make it if I can. And it's
Okay.
what Brady said. And that is, you're right, Frank, that may not have been done, but since 2010, upon a request, a museum has 90 days to identify those tribes that are Aboriginal land tribes. The requirement under the existing rule is that within 90 days of a request from one tribe, all of the tribes that are potentially geographically affiliated, to use that term, instead of Aboriginal land, a museum must notify them. So right now there's a requirement for museums to do that work within 90 days. Just to be clear where that burden is right now on a museum today is to respond to a request by identifying those tribes. So sorry.
And as Brady said, if they all come in at the same time, it could be a real problem for museums. But what I'm suggesting is that if these regulations go final, as you just described what they would require, that all encompassing need to determine geographical affiliation will be placed on all the museums and agencies. That's, I think, one of the things that they may be concerned about. I think we see in the letter from the Field Museum, for example, there's some concern expressed specifically about geographical affiliation. So I'm just pointing this out as a general, I think, a general problem with the way that new, and I do think they're, well, I think it's additional, whether it's new or just additional. We can debate that. Can John go on now? Go with his comment.
Oh, thank you.
Madam DFO, you finish. Thank you.
Thank you. And so I've got a couple of different comments here, but I'll address one of the ones that's right in front of us right now. And so a question I have then about the ancestors, or if we're going to get the current designation is CUI right now, and the associated funerary objects that go along with them. And we're having some discussion about, and it's understood about the additional research that would potentially need to happen. My question right now is for those that are maintained in those collections, what purpose are they serving if there are so many unknowns? What we do know is, and I guess what I know is, if the dating is so older, if you will, but what we do know is those are not Western civilization, for the use of the term, peoples. I'm trying to, not being perhaps acting as a stand-in, I'm saying that part we do know, that they date before, potentially before, if we're looking at some of those that date before contact and even post contact. So if they're existing in museum and university collections, and if the research is not, has not, or is not going to, I think we want to be in support of further information coming in that we can, but I guess where I'm at, what purpose right now are they serving? Is what's the, what, you know what I mean? What is the, I'm trying to consider, and also one coming from a Native community, what tell me, you know, I won't say justification, if they're just going to be maintained there for, you know, because they exist as a CUI or an unknown, then what are the steps that are going to be taken, you know what I mean, that are going to be taken to, because if they're being maintained, particularly in research institutions, I would say there's a responsibility, you know, or even museums that hold those collections, or if you're going to put them on display, they're so old or whatever it is that we don't know what they are, but hey, here are some funerary objects that are on display, or here are some funerary objects because of the way they look, or that perhaps they exist as an artistic item, if you will. And I'm not saying that to be insensitive to that, but I think I think perhaps that is a feeling that perhaps many Native communities have, particularly about what this difference between the new 10.10 and 10.11 are trying to accomplish. I think I'm probably going to different areas, spinning into different areas here, but when perhaps descendant communities, even as they're making these claims, are presented with a return process that includes that might result in the return of the ancestors, but not funerary objects, because they can't be pinpointed to an exact individual. I mean, I think that there are certain, I won't say that there are loopholes in here that are certainly being exploited by, you know, or looked at by certain, or perhaps a number of institutions. And that's a frustration, I think, for descendant communities. But when and I think that to say there are various forms of, I think we can all recognize various forms, and perhaps we're providing some sort of guidance in which the museums or institutions might be provided to do this additional research. I think most people on this committee have done or are experienced in research and know what additional research entails. I've been on both sides of this, working for an institution and being a part of a tribal organization, or work with tribes, and know how burden of proof, or arguments can shift on where the burden of proof is. I think we've had a very interesting discussion. Well, we won't enter into this, but from the UCAL, the NAGPRA thing about these, and I made some comments during that about what lines of evidence, you know, and how that's weighted. And that's certainly a frustration where I think Native communities, particularly with oral histories or tradition, or what we know about where we came from, is often the scale is often tipped in what we would call like scientific rigor, or what institutions seem, what museums that are holding these collections, what they seem to know or will provide the Native communities in the repatriation process. I certainly think that these institutions have much to learn, and I certainly have, as an individual, have much to learn. I think everyone has much to learn from the consultation process, and if in a broader sort of statement or context about where museums, if they're looking at how they exist, or how the collections can exist in a very sort of being relevant, you know, where they exist in sort of day-to-day real world discussions, if we're talking about particularly where NAGPRA or working with descendant communities is concerned, I think that these Native communities have been telling you how these collections, if we're looking at the ancestry, the human remains, the funerary objects, while that may result in a return to these communities, that's a present day how these are relevant to discussion. So I don't mean to be sitting on my soapbox here, but I think that if there are, and I think we hear concerns about the additional work that might be required here in terms of what this new thinking in the regulations, but isn't that what museums and institutions do? We are supporting research. And so going back to, I guess, some of my earlier comments, if it's going to be continued to be unknown, or a position of being forceful, saying these are unknown, we can never know anything, it's impossible for us to know, then what's the position for, particularly, as I was saying earlier, for retention? And I think that's a very real frustration for Native communities. And so I go back to when I look at the difference between 1011 as it exists now and 1010 as it's being proposed in the proposed regulations. I don't know if this would be something that Melanie might want to ask, but what I'm reading into this is it wants to accomplish those certain things, and moving this process along for all parties involved. But it also seems to have listening or heard some concerns from Native communities. I guess right now, I know we're heavily looking at the term geographical affiliation and how this fits in. I think that perhaps that, as we heard earlier, this is not perhaps the end of that discussion as this opens up more. And I think that perhaps even that definition may or may not change. But I think that what's being proposed and how it fits into the change here, I think there is something that National NAGPRA is wanting to accomplish. Am I incorrect, or in my assumption there, Madam DFO?
I'll just correct to say that it's something that the department is interested in doing, not the National NAGPRA program so much, but the department is interested in, yes, decreasing the burden on everyone in the NAGPRA process by setting deadlines for the process to move forward. We do see the draft text and this requirement as alleviating an ongoing burden on museums and federal agencies to respond to those requests for culturally unidentifiable. Certainly, John, I would agree with you that the purpose here is to move the process forward, to complete the regulatory process for as many Native American human remains as possible based on that geographic origin information. We know from statistics that in the draft text, the way it's drafted right now, something 90 to 95% of the human remains that have been identified in a NAGPRA inventory could be geographically affiliated and complete the NAGPRA process. That is the amount of culturally unidentifiable human remains that come from a known geographic location is about 90 to 95%. And that those could finish the regulatory process and complete the process under the draft text.
I have two comments. One to John, and I very much appreciate his perspective on what is the scientific value of some of these sets of remains or funerary objects. But that's not the question that's being asked of the museum and the agencies. That would be a different kind of an approach, and it might be one that somebody wants to give some thought to, and things that in our present understanding of scientific value, and someone would have to come up with a definition of that, seem unlikely to provide important information or contextual information that's important. maybe they get treated in a quicker, rapid repatriation way. I'm not suggesting that is what you want to. It just would be a different kind of an approach that some people might think was maybe more useful. Melanie, I just had a question about your comment that 90 to 95% of the culturally unidentifiable Native American human remains in the inventories have sufficient geographical information. What kind of information do they have? What is meant by sufficient geographical information?
They are identified at least a state, if not a county, or if not even more specifically to a site.
Okay, if they're affiliated with a state, and that state doesn't happen to have any information about treaties or all these other kinds of information that might link a tribe to a state or a portion of a state, more likely. How does that get at the cultural affiliation of a tribe, or a geographical affiliation of a tribe with the state?
Well, I would be interested to know of a location in the United States that does not have some form of treaty or negotiation between colonial governments and the Native Americans at the time of contact. It's, I would say, pretty universal across the United States. And if we're talking about the colonies, in colonial interactions, for there to be treaty negotiations, even if they were peace treaties that recognized which Native American groups had control over land that was becoming a part of that colony. It's very common in the records of the Massachusetts Bay Colony, I'll tell you, because I've studied those in the past. Each little town was negotiated between the Massachusetts Bay Colony and the Native Americans who claimed that land.
And that information is in the inventories now?
No, but that information is well studied. I can't.
One could access it. One could access it.
Certainly. I mean, scholars on Native American history have written monograph after monograph about some very small exchanges. Certainly there's a plethora of information out there about that history.
But that process would need to occur. It hasn't occurred already.
Well, again, it would be a matter of accessing known scholarship, known academic information. This is not unknown information. Like I said, I can't think of a more studied source than the records of the Massachusetts Bay Colony in terms of early America. Certainly, we know, I just got back from a vacation on Cape Cod where we know exactly the names of each individual that got off of the Mayflower. We certainly have a lot of information about who was standing on the other side when the Pilgrims arrived. It's not. This is well-known, well-documented history. Certainly, there are plenty of reference books I could point to, American historians who have been studying this information and these written records for decades.
Now, I'm familiar specifically with Cape Cod, actually, and some of that information. So we know who was on the Mayflower, indeed, but I don't think we know exactly who was standing there. In fact, they weren't standing there waiting for them. They were watching them very closely, but not coming out to greet them. I'm sorry, that's an aside. John, you've got your hand up.
Yes, I wanted to follow up, and I certainly not misunderstand about the protects the scientific knowledge that could be discovered. But also, I think other places are certainly recognizing that, but in consultation with, and I guess this goes into the question about the research involved with perhaps, if not one, multiple descendant communities. But you made a follow-up comment, which I wanted to follow up on, about context. And so if this, whether it's if it's being viewed as a new requirement or whatever, this newer line of research, would it not provide more context to the ancestors, those collections? And to follow up on Madam DFO's comments, I said, as I was saying, we've all done research in our own capacities. I've worked on both sides, particularly on the repatriation side, working on the claim side, but also as someone working, researching a repatriation claim. If you're going to do that, I mean, you dig deep into the research, and whether that's, and I think the research, one, it further supports the context of those collections, and even and if ultimately that's going to result in a return to said community or communities, that's going to be information that, ultimately, and as you're working with tribes, but that is providing context to that, and it's not unknown, it's not completely unknown information. And perhaps as you dig deeper, either you're on either side of the sort of the research question. I mean, you are adding to additional knowledge, and sometimes you come up on things that are this, I won't say discover, but you come up on new things that you discover in the lines of research. So if there's that question, so a lot of this information is not unknown. We talk about looking at various, I think we kind of focus on treaties, either pre or post the the establishment of the United States or not, but there are multiple lines of information. And if I'm not just saying, just from how I conduct research would be conducting research. I mean, there are lots of things I think that all of us who've been involved in research that we look at. And if you have a question who was there, and I think if we're looking at, and even from, if we're not 100% behind the geographic, that terminology, if we're looking at where peoples were, I don't think that is, or where certain tribes were, tribal nations are or were, and I say this as a removed tribe, a member of a removed tribe, in a homeland, or we call it our home in Oklahoma. That's really, we're not from here. We're not from here. And so, and I think lots of people, or if that's a part of the educational process, I mean, letting them know that we're not from here, but how we're connected to other places and that were our home, that were our traditional homelands, or where we came from. And I would be ultimately shocked for those who were scholars in the area, what I mean? They know we were there prior to our, not just my tribal nation that's here in Oklahoma today, but who else was there in those areas. So, I mean, if this question is going to move, it sounds like another requirement, and perhaps there would, there are the concerns that they're going to be heard, but it is adding, I would say, or adding some, ultimate more context to whether it be the human remains or the collections that exist. And I, to continually say that we don't know, or either with this requirement, or if it's a new requirement or not. I mean, I'm not 100%, I can't buy that argument, I don't say argument, but that position that it can be, ultimately, unknown. We provided examples of lines of, I think, that are being provided in some of our discussions, or what's being presented in the proposed regulations, but that's not limiting. And so I guess that's some of that, what I'm gonna say, what I'm afraid of, or whatever it is that when in previous regulations where it had seemed like where it's been limited, oh, well, that wasn't mentioned in the regulation. So we didn't research it to that degree. I mean, that's almost been a position that some of these institutions have taken because it wasn't, certainly explicit, in there. And so while we can look at, say, hey, these are these things that you can look at, but I think, if you're well-versed in your research, you're going to know it goes beyond specifically what's presented there in the, in the regulations or what's being proposed.
Yeah, other committee members have comments on this matter also? Tim?
I'm sure. Personally, I'm generally sympathetic to the idea that to require museums and federal agencies to revise their inventories. I'm sympathetic to that idea. However, we can't be Pollyannish about what this is going to cost. And there's two pieces to this. One is compiling all of the information about all the treaties and other documents for each individual location across the country. If these regulations put that on the back of the museum to identify those geographical spots, there is going to be a redundancy of effort. Whereas if a central agency pulls all that information and puts it together, it will be more efficient. But the second thing that I don't think we're factoring in here, and I think Melanie had sort of mentioned comparing the draft proposed rule with, I think you said, the 95 regs. An important thing to remember is that museums and federal agencies at the first instance were required to complete their inventories of Native American human remains and associated funerary objects on November 16th of 1995. And the majority did. The majority sent those documents in. And I know that was during a government shutdown, so that when we all came back to the office, we had plenty of inventories where they sent copies to us. But the important thing to remember is that on November 16th of 1995, 43 CFR 10 did not exist. Those initial inventories were not done in compliance, or not required to be in compliance with the current regs. So if we're asking museums and federal agencies to go back and look again and revise their 95 inventories, we're also asking them, in many cases, to meet a new standard for cultural affiliation, not just for the geographical affiliation. So it's not a small task. And I would actually think that it is akin to the task that museums were required to do between 1990 and 95, albeit for a smaller, slightly smaller pool of Native American human remains, 110,000 or whatever that current number is. But it's still a big number. And there's now 25 years more documentation that they have available that may address cultural affiliation, not geographical affiliation, but cultural affiliation. So getting through to that is not a small task. We should not, I'm sympathetic to having them do that, but I do think we have to be very clear-eyed about what it's going to cost. I've done some preliminary analysis just on grants that have been awarded to museums for documentation work going back quite a number of years, and comparing that to the number of notices they actually produced during, actually any time during the period, not necessarily within the grant period, but for the entire period that I looked at. The number that I come up with in order to do this is probably around $50 or $60 million. And if we as a committee can urge Congress and the department to support that kind of expenditure, to support museums to do that, I'm in favor. I'm actually skeptical we can do that, because that's a lot of money. But this is not going to be cheap. And if they're going to do it, we need to make sure we can do everything we can to make sure the money's there.
I just want to clarify that NAGPRA grants are based on voluntary projects that museums develop to address collections and repatriation work. It is not a standard by which all other museums would have to meet. There are ways, and there are plenty of examples of museums who have completed their NAGPRA work and published notices for very, very little money. We have volunteer staff who have completed this work. It's a lot about how the museum decides to approach the work in terms of what the costs ultimately are.
Sorry, John, your hand is up. I was on mute there for a bit, sorry.
Yes. And so I certainly, with my longer comments, I think we certainly, I certainly recognize the amount of work and perhaps the new expense that that could and will be involved in the process. But I did want to follow up on the Madam DFO's comment about not just the grants that are available, but I also wanted to go back to a sort of an earlier statement about particularly this section in general about how burden of proof is shifting, particularly in this area. And while we certainly have this monetary discussion, to that point, I would like to say that tribes have invested a lot of their own resource. So if we're going to, I just want to point that out as we're moving forward in this discussion, that particularly if we're talking about CUIs or in this process, tribes have, in addition to having a number of them having utilized the NAGPRA grants in support of this, tribal nations have put forth a lot of their own resource over this period of time to work to make these repatriation claims, particularly when the burden of proof is on them to do the work, to establish the work involved, to do the research and establish the claims they're putting forth for these perhaps these collections in question or the work involved. So I don't want that to be lost in the discussion either. If we're and even with the newer what's being proposed here, there may be some newer sort of I would say, requirements or the financial, I won't say burdens, but that are passed along in this as a part of this, perhaps part of this consultation process. But I did want to point out that tribes over this amount of time have put in their own significant parts of their own financial resource to these efforts prior to what newer burdens or that we may be looking at. So I don't want that. I don't have a dollar figure on that, but I know a number of tribes, particularly here in Oklahoma, my own included, we put a lot of our own resource into doing that, financial resource into doing that, doing that work.
Thanks. Thank you, John. I do think I think everybody or all the different communities that are involved with trying to implement NAGPRA have expended a lot of their own money as well. They haven't been really, we wouldn't be nearly as far along as we are if we were relying upon NAGPRA grants to do all this work. But I think it is, and I think it is useful to have some sort of specific data that we can look to and maybe help us to project what the long-term cost might be. And the thing that concerns me is if the new regulations impose the additional activities across the board, because they impose activities on tribes, because tribes then have to react when the museums go to them. And sometimes that doesn't happen because the tribes don't have the staff to spend the time on these things, or they have staff, but the staff may be assigned to other kinds of activities, which happens in agencies all the time. So what I don't want to have happen is that there's a new set of regulations and it has a set of guidelines, a set of deadlines and things of that sort, and nobody is able to meet them, or only small percentage is able to meet them, and then people just get more frustrated. So so I think that's why we're having this discussion, is to try to identify where some of the choke points might be, for example, or where some of the useful things might be. I don't think that requiring a more intense look at potential geographical affiliation, I don't think that's a bad idea, but I do think that it will take time, and time is resources. Time is time for experts. And I appreciate Melanie's comment about, well, some museums have been able to do this in a relatively inexpensive way using volunteers, and that's wonderful that there are people who will volunteer work at museums. But Melanie also talked about digging into the resources of the Massachusetts Historical Society and looking at early colonial records. And there may be some volunteers who could do that competently and efficiently and understand what they were looking at. But in many cases, it's going to require some level of training or expertise to do that, and some, professional staffing to do those sorts of things as well. And I think we have to recognize that. And I think as you've been saying, John, I agree with you. I think that that additional information, that new information, will be useful broadly as well. It's not just to accomplish this particular task. How do we ensure that it gets done properly, that it's not just an incomplete or a job that's not well done, and that in 5 or 10 years after, some people are wringing their hands and regretting that it got done in that manner. I think we want to avoid that kind of thing. And our job is a difficult one. How do we do that? How do we try to ensure that kind of isn't the outcome? The outcome is an outcome that people think is a good outcome. I don't know where that leaves us exactly with this. We've talked about the process. I think it's fair to say there's some disagreement about how quickly or easily or more difficult that process would be, how much of it is already done and just requires looking at it in a different way, and how much of it needs to be done anew or in a more complete fashion. We've talked about we talked a little bit about the sources of information.
Could I ask a question?
Sure, where are you? Go ahead, Melanie.
One recommendation from the committee might be that timelines are needed in the inventory process. As we have discussed, the variations of what was required in 1995 and when the regulations were promulgated, and then to today, but there's a long period of time there. And so there is currently no obligation on a museum to revise or relook at decisions that were made in 1995. So the question, unless there's a request from a tribe. So the question is, should museums have to revisit inventories and update them? That's a yes or no question that might make a good recommendation from the committee. Does the committee?
Sorry. It's a yes or no question that may have some caveats on it, like yes, but in terms of resources to do it. John, you had your hand up. I see it's down now. Or not back.
Yes. And Melanie just put forth, particularly in terms of, or Madam DFO put something forth in terms of, I guess, timeframes or deadlines. And I think there's that was going to be one of my follow-up questions, because I know that there are some timeframes and deadlines that appear in the proposed draft, particularly with some of the discussions we've been having right now. Madam DFO, do you have any insight on how the length of time, the deadlines that appear in the proposed draft, how those were developed, or how they were sort of how you came upon those, how the department came upon those?
Certainly, John. They're the first deadline in terms of an inventory and update of an inventory is required within 2 years. And that relates directly to the requirement for new collections that a museum might receive under the existing regulations. If a museum receives a new collection of Native American human remains and associated funerary objects, they must produce an inventory within 2 years. So that's a parallel timeframe. Incidentally, I will note that NAGPRA and its requirement for updated inventories was also 2-year timeframe. So there's some consistency there in terms of 2 years for these inventory update requirements. In terms of a requirement for a notice to follow 6 months later, that is directly from the statute itself. That requires a notice if an inventory finds cultural affiliation within 6 months.
Thank you. And I know that we've had some, and perhaps that answers the question, Madam DFO. But I know Frank has certainly presented. We've heard some comment or question about revisiting these inventories, and there have been, I guess, we've heard some comment about that perhaps that the time frames, the time being that you just spoke to being presented are, I'm going to say, being that we're hearing about perhaps unreasonable or it's not that having difficulty being met. And so to your comment, particularly where CUI are concerned, and how to now accomplish, or how they're going to accomplish perhaps what was being viewed as a new requirement. And so I think you answered it, but that's how you came up with the new time frame or guidelines to address perhaps the new requirement. Then correct? Am I understanding you, or understanding you correctly? All right. Thank you.
Madam DFO, I wonder if we might do a little pause here. And then I have the sense that we're making some progress in identifying certain issues about the inventory requirement and timelines. I think it's not a bad thing to have timelines. And the costs of the possible costs and how they relate to timelines. Maybe if we took a 10-minute break until 2 o'clock, we could come back for another half an hour and see whether there isn't some way of encapsulating what we've talked about in a text. And see whether we can try to find a way forward on a recommendation regarding the new inventory requirement, or the inventory requirement, the change to the inventory requirement, and timelines and things of that sort. I think we could all use a sort of a breath of air to maybe a little time to clear some of, and focus on things like that for a little while.
Certainly. And I would like to note that we do need to reserve some time for additional public comment. And I have received some comments that I will read as a part of that public comment period.
Okay, well, we'll be sure to allow for that. And we may have old business or new business. I don't know. We can see about that as well. Okay, 10 minutes. Madam DFO, thank you.
Okay, our time is up. If you could please rejoin the meeting. Mr. Chair, if you are back with us. Give Frank just one more minute to come back and join us.
Sorry to be late.
Right on time.
John, your hand's up.
Yes, thank you. I know we're getting ready to move on, but if I could just one last comment. Just sort of a follow up to everything that I've said. I certainly don't want to there's not the impression. I have a background in science too, so I can certainly appreciate the science part. I've worked in museums a long time, so I'm certainly in support of what the work that museums do and the work that they want to accomplish. Saying that, I know we're talking about here, particularly what the question about looking at these newer sort of requirements. What I really want to finish with is that there's great opportunity here, and whether it's a new requirement or they're looking at the part of the newer consultations that might or consultations that museums may or may not have to have with additional consultation with these tribal communities. And I guess and I've read some of the letters and the comments that we received, but I think instead of looking at that as sort of this additional step or even sort of an imposition or something that's going to this new additional layer, to me, I look at that as a great opportunity between museums and descendant tribal communities. I mean, there is work behind it, and perhaps a lot of work behind it, but I think it's worthwhile work. And I think a lot can be accomplished as museums, or if this is going to be a new requirement, that museums can learn not just about those potential, if we're going to call them the ancestors that fall under the umbrella of CUI, or the cultural items that still remain or that are perhaps in question as a part of these consultations. But to me, I think that contributes to, and even if there are some statements that tribes make about they have cultural concerns about the types of information that ultimately gets presented, but I think that is a healthy part of education, and a lot that can be learned between the universities and institutions, rather than it being this new step or an imposition. There's a lot of opportunity that can happen there with these new, if you're going to look at them as this new requirement, these newer consultations. So instead of that being a barrier, I think that is great opportunity for good things to happen. It may result in some difficult conversations between tribal communities and the museums and universities. And I've certainly been, have heard those concerns working for museums in the past, but I think it's something that those are needed conversations, and there's a lot of education, and and I think that can spread out, not just from those internal conversations, and you want to be sensitive to the things that are being discussed, but I think that finds its way into how museums make their presentations with the collection. So it's not just that part of the repatriation process. I mean, it informs museum staff on how those presentations are made in the museum collections, and extending to things like public programming and one thing, things like that. So instead of being looked at as sort of a barrier or this, this flashpoint, that's ultimately what I want to point out. There's great opportunity here to either develop relationships, mend bridges, if you will, but there's a lot of learning that can happen on, rather than it being sort of, portrayed as this sort of this adversarial relationship. If it is adversarial, maybe it's an opportunity for it to move beyond that. So that's sort of my comment on that for today. I think final comment for now, but I just wanted to express, that as well.
That's an excellent way to actually begin our discussion or to continue our discussion. Yes, I quite agree with you. I think there are opportunities. One of the concerns that I've been trying to express is, in order to take advantage of those opportunities, people need the resources to do it. And where will those resources come from? And they need time. I think when we were talking to the assistant secretaries, I tried to make the point that I know communications is very, very time consuming. And it is also one of the most important things in developing relationships and continuing relationships and building good relationships. And it takes time. It takes a lot of time to do that. And we're talking about a lot of connections here. We're talking about, the museums connecting with the remains and objects that they're responsible for, that they're trying to care for, connecting with the data or information that they may not have on hand, but that may enlighten them in terms of geographical affiliation. And we're talking about the relationships with the tribes, with going out and talking to people and talking to people, a lot of people, and a lot of times. So how do we, and we're dealing here with regulations. The regulations are going to become final, and organizations and individuals are going to be required to do certain kinds of things. There's no guarantee that new resources will come along with those requirements. They're not. There's not a link there. That was one of what I asked that question of the assistant secretaries about budgets in the out years, and they recognize the need, but they also recognize that there's a lot of needs, and we'll have to see whether this particular need gets the attention that it deserves. I don't know if there's a way that we can guarantee that in the wording of the regulation. We can certainly point it out in our recommendation, whatever our recommendation happens to be on this matter. So what are the points we would like to make that we, the review committee, would like to make to the Secretary of the Interior and her staff about the proposal to let's say the proposal to enhance the existing inventory information and to focus more attention on geographical affiliation as a means of establishing a identifiable relationship between tribes and NAGPRA collections that museums hold. What are the points? Well, I think Melanie gave us one when she said timelines. And I think we need to include something like that, because that is something that has been in just about every formal statement or letter or comment that the Department of Interior has issued about these regulations, that there should be a new urgency to to executing a process that works. So that it makes sense there. Well, what else can we say? We can say is that this can be mutually beneficial. Be beneficial for the tribes, be beneficial, but as well for the museums. Just some of the ideas that you just articulated, John, would you capture some of that. And we should make the recommendation that in order for this to work, and particularly in order for it to work in a speedier way, if we want to use that term, we may not want to use that term, there are going to need to be some kind of new resources devoted to it. Some of those resources may come from the organizations involved, from museums or the tribes and the tribes. They both may have a self-interest in improving relationships between them or among them. But the agency, the Department of Interior, which is trying to improve the process, and part of that improvement is making it quicker, should plan to put some resources to the organizations as well, that they can't, in order to improve the situation, it's unlikely that they can do it just by publishing a set of regulations that say that they should do it. In fact, that may create a worse relationship than exists at present. Those are three things we could say in a recommendation, or three parts of a recommendation that we could make. Madam DFO and manager of the National NAGPRA program, would that be of assistance, do you think? Or
Yes, I think whatever input the committee could give the department on updating inventories would be beneficial.
so one guidance would be, yes, we think they should be updated. So
Just like to make up
the 4 points. It's really hard draft. I mean, text drafting in this particular technical forum that we happen to be in is
that's where, if you can focus on the yes or no questions, it could formulate an easier process. So if the question is, should updated inventories be required? The review committee agrees updated inventories should be required. That formulates your recommendation. I do want to stress that as much as you might want to work on these specific statements now, and I think that's a great idea, I would want to wait until your next meeting to vote on those recommendations, given that we are down 2 members today. But I think that the clarity of that statement, the review committee recommends inventories should be updated, is a up or down vote for the committee to come to a consensus on.
I think we could probably do a sense of the committee right now and have an official vote next time. Is that fair?
Yes. Does anyone object to that statement?
I object to it without some of the qualifications that I think are necessary to be in the recommendation. And some of those are what I think, in part, what John articulated in terms of mutually beneficial. The process should be mutually beneficial. We might have some influence there in the way that it's described. The process should be assisted by resources being provided by the Department of the Interior or the federal government or some other kind of entity. Those 2 things anyway. I don't think the single bullet updated of inventory should be required is sufficient, I guess is what I'm saying. Although it's key. I get that. Is required, and there should be a schedule for it. The process should be established So that is mutually mutually beneficial.
Might suggest again, if you want to take the time between this meeting and the next meeting to craft that recommendation, that might work as well.
Mhm.
And if I could take the opportunity to throw in one that's sort of a pet peeve with me and probably will be controversial, which is probably just, it is what it is. The statute says that the inventory is to be based on documentation, and that the term documentation shall not be construed to be an authorization for the initiation of new scientific studies of such human remains and associated funerary objects, or other means of acquiring or preserving additional scientific and information from such remains or objects. That's Congress telling us that. So I think it is important for us to acknowledge that these revised inventories are not an authorization for the collection of new scientific information or new scientific research or documentation. And it's Congress said that. It's in the statute.
Tim, what if, and I don't know that this would be common, but in order to reach say a reasonable determination of geographical affiliation, someone needs to go to the, we'll use the Massachusetts Historical Society hypothetical, and spend a day or 2 days poring over the any treaties that relate to Cape Cod. That's Melanie brought up Cape Cod as a location. Is that new scientific research?
Not according to my read of the statute. That no new scientific research or collection of information only applies to human remains and associated funerary objects, not to documentation.
Well, I mean, somebody could say, well, you are doing research because you're spending 2 days in an archive investigating information that you don't already have at hand. It's not necessarily about us. Well, maybe it is about a specific set of human remains that has some ambiguous geographical affiliation that can be clarified, potentially be clarified. You never really know what's going to happen with you know, a 2 days of work in an archive. Wouldn't that potentially be the reading with that in that specific the way in the phrase that you read, that somebody could say this would be new scientific research and it shouldn't be undertaken or allowed?
We asked the lawyers to parse that sentence for us.
So the section of the statute that Tim's referring to specifically discusses further scientific research of human remains or associated funerary objects. The research you're describing here would be about determining the tribes with which one might consult, and is really research related to knowledge about tribes and the geographic locations with which they are associated. It's not about the remains or objects, it's those we have the information already that we need to have a geographic point, for example. So I think Tim said it correctly, that section of the statute that is intentionally pointing out that Congress didn't intend for further scientific study is limited to the scientific study of the human remains and their associated funerary objects. This would not be construed as part of that. It's more of a procedural step in the NAGPRA process, not the substantive review of those. helpful?
Yeah, that was helpful. Thank you. Yes, that was a good answer. Thank you, Brady. I'll stop talking now. John, you have your hand up.
Yes, I was just following up on the, I thank Brady for his comments, but and part of that was what we're discussing earlier. And so, I mean, I think I would see the further research that would help support or the context for that. Well, I guess when we're looking at along the lines of the further scientific research, certainly someone proposing, well, hey, we need to study the teeth, we need to study bone mass density, we need to do this in order to determine which could, which could provide, we're trying to provide an argument for further research, which I think some number of tribes have presented that enough is enough, and so
Sure.
we're presenting a claim, and now someone is saying, well, in order for us to, to do that, we need to do further measurements on or do studies of teeth or bone mass or something like that, or try to compare this to, so I think that's where that fits in and where it further stalls the process. Now, if it's in consultation with that, now I'm not proposing to speak for all the tribes, but if that's in consultation, or a part of a broader relationship that museum or institution has with that specific tribal nation, then, but certainly not to keep presenting these new opportunities presented as new scientific research, which can be viewed as holding up the already documentation or repatriation process.
And I maybe again, this is sort of word crafting that we should try to stay away from in this context, but maybe a specific mention of research on Native American human remains and other NAGPRA related objects or something like that put in there would clarify that, just as you said. Shelby, yes, please.
I'd like to add that over the past 30 years, just even the term or understanding of what consultation means has changed considerably. And when I think inventories that were done back in, in the early 90s, the level of consultation that was done back then might have just been a letter to a number of different tribes and nothing beyond that. And I know with my own experience in some of the museums I've worked in, we've learned a lot through face-to-face consultation. We've actually been able to culturally identify some of the ancestors in our collections through that consultation that were considered culturally unidentifiable. So I think recommending that some of these collections be re-inventoried and bringing new research. And of course, there's new staff. There's a lot we've learned about NAGPRA over the 30 years that can make a huge difference, I think, for probably identifying some of these ancestors that are in collections.
Thank you.
I think the consultation process in particular has changed considerably.
Thank you. Madam Chair or Madam DFO, you suggested that one way for us to proceed that might be more economical of everybody's time would be to have, I don't know if you were going to make a formal subcommittee or suggest that, or probably should be a formal subcommittee, I guess, not just an administrative meeting, because we would be talking about substance. But if one or two or three or four of us got together and tried to come up with an actual text of a recommendation along the lines that we've just been discussing. Was that where you were going?
No, I was suggesting that one of you develop the written statement along the lines of Tim offering to prepare some written
For section 1.
on 10.1, that someone else take on the task for this specific issue to draft the recommendation.
Okay. Any volunteers? I'll volunteer to help, but I would like someone else as well. Oh. Okay.
Okay,
Well, another alternative would, Frank, for you to draft something and share it with the committee.
Send it around.
Yeah, that's what I was going to suggest is maybe if somebody could start the draft and send it around to the rest of us and we could comment on it and add to it or whatever.
I think actually, I think that's a good idea. All right, I will start a draft and send it around to everybody, not just the 4 of us, but the full committee for comment.
and Frank, if I could, just to follow up on what Shelby said about consultation, the proposed rule actually does include a specific definition of consultation, which is taken directly out of the legislative history, or pretty close. It's a close paraphrase, which I think gets us a long way towards having a real definition.
Okay. So reference to that section
Yeah.
in this would be useful.
I mean, we can decide whether we want to go further, like in NAGPRA, because that one does go further. But this one that they've used in the draft here is actually out of the House report.
Okay. Do you recall what section it's in by chance? Is it in definitions?
I'll get that for you. It's in the report. Oh, in the draft proposal?
Yeah.
Yeah, there's a definition of consultation in the draft proposal.
Okay. But in the definition section, section 2, I think. Okay. Okay.
And I don't think I've complimented Melanie enough for making sure that that definition is in there.
That's good. Good. We should always use praise when we can.
I will convey your compliment to the department.
Okay. Okay. So that's as far as we've gotten with our definitions. Melanie, you want to have some time for public comment? I wanted to see if there's a new business or old business that anybody has anything to say about or wants to do anything. So can we do that quickly first, or any new or old business? Okay. Shelby, go ahead.
Yeah, I'd like to suggest that since we have 3 of our members that will only be whose terms are ending after our next meeting, to think about our report to Congress and especially get input from John, Honor, and Barnaby, if possible, of what their thoughts are about what should be included in our report to Congress this year, if that would be possible.
Okay.
That's going to come up.
We would need to do that, I guess, at the next meeting, as to what their recommendations would be. And John, would you be able or interested in drafting something along those lines and consulting? Who's on that committee? Honor is one. Is Barnaby's not on it, is he? No.
Frank, I'm not sure. I mean, how that committee exists right now. I'm not sure if I currently sit on that committee because of previous discussions about where, where our terms were ending on that. So I'm not sure that I'm a formal member of when that committee put itself back together in terms of thinking of moving forward for next year's report. I just bring that up just as
Yes,
matter of
okay. I don't recall myself, actually.
So just to clarify, I think what Shelby's asking is for individuals to provide their input on what might be in that report to Congress. So John, if you were to be able to put together your own thoughts on what you would like to see included in the report to Congress.
Sure, I will. I can do that. I guess we can present that or talk about that at next week's meeting. Then, correct? If that's okay as a part of process, I guess.
And I think, Frank, if you could let the other two members maybe let them know that we would like to hear from them as well at our next meeting, as far as any barriers, challenges, any other issues that they would like us to report to Congress would be very helpful.
Right. Just making a note here. I have an issue that's also all business, and I just wanted to raise it because it's been something that's concerned me since the very end of our last meeting, where we talked about the 7th member list, and I frankly don't know if there's anything we can do about this, but I'm concerned that we're not serving the secretary very well by only sending up the 2 names that no one objected to. And I don't necessarily have a qualm about those 2 individuals, but they're, in terms of their characteristics and experiences, they're seem to be quite similar, and I only know them from what Barnaby said about them. There were not quite a half dozen other individuals that one member objected to that have a range of different experiences. And I think, and I don't know how past review committees have handled this, but I think one of the things that the committee should consider in developing the list that goes to the secretary is that there would be, of course, a list of individuals that everybody agrees with, but also a list of individuals with different experiences, all of them important for the secretary, from which the secretary can choose. And I don't think this particular list of 2 does that. So, Madam DFO and manager of the National NAGPRA Committee, what's the status of that list? Has it been sent forward, or what's in terms of protocol or committee procedures? Is it possible to revisit that issue?
Well, just to refresh everyone's memory, the requirement in the Act is for a list of persons developed and consented to by all the other members. So it does require that consent by the other members to the list of persons. Past practice has shown that sometimes specific individuals are not consented to by all the other members and have been removed from the list. So that's not an unusual occurrence. And lastly, Mr. Chair, you called for a vote, and that vote was finalized. So the committee had developed and consented to a list of persons that included those 2 persons. There's no requirement for diversity in that list, as you're suggesting there's no requirement that the committee provide a certain different types of persons.
No, I understand that. I understand that. Otherwise, we would have done that.
I was just going to add that in this case, I know we're looking backward at a decision that was made at a prior committee meeting, but if for future decision-making processes for the committee, if you were concerned about the approach, you as the chair have the authority to define how you run the discussion and the approach and ultimately end up at a vote or determining consent. So
right.
We could even discuss more administratively how we could address any concerns you have with that process in the future. But the committee's decision has been made.
Unless the committee members voted to reopen the issue, I suppose. And I guess I just raised it to see if any other members sort of shared my concern about this and whether I actually think as I rolled this over in my mind after the meeting and for several days and weeks afterwards, that if we had had more time, that issue might have occurred to me to raise at that moment before we completed the process, as Brady just reminded us that we did. So it may simply be something for consideration in the future, not something that I would be involved with, but something to think about in terms of this particular process. I guess I'll leave it there. If no other committee members have any comments on it, we should move on. John, please.
Yeah, I'll just say, we went through the process, and that's where, that's how I feel that the decision we made the formal decision as the committee. And if we're going to reverse the decision, that's what, that's also as part of would be part of the discussion. Reverse the decision. We're talking about that we agreed upon via that process. That's a deep. That has certain certain points that we would have to discuss deeper. Yeah. That's like discussing reversing the results of an election.
Let's not go there.
but I'm just, if we don't, what I mean? If we've gone through the process and we're well past it.
I know exactly what you mean, John, and that's why I even hesitated to bring it up. But it has, as I said, it's something that was on my mind, and I just wanted to raise it. I think in part, as I said, I think this particular format that we're meeting in, where we're up against a hard deadline. Once the meeting's over, the meeting's really over. And there's, in the last case, there wasn't really an opportunity. That was the last meeting we had in March, and this is the first meeting we've had since then. So there was not an opportunity for individual members to say, take a pause or something. And again, it's not something that I thought to suggest at the moment. So maybe something to consider for the future. If there's no other comments, then Madam DFO, you want to move on to
yes.
Public comment?
Yes, so we have an opportunity for public comment. Again, you can put your name in the chat or raise your hand if you'd like to make a public comment. Before that, however, I'd like to make just two brief announcements. First is related to the review committee. There are currently a notice soliciting nominations to the review committee. I've posted that in the chat. Those nominations are due on June 13th. In addition, I would like to let everyone know that next week, the Department of the Interior and the Department of State are holding 2 tribal listening sessions on the topic of international repatriation. Letters were sent to tribal leaders on April 19th, The listening sessions are on Monday, May 9th and Tuesday, May 10th. And I will put a link to that registration in the chat as well. Just wanted to share that. That is a tribal listening session specifically, but I was asked to share that information here. We did have some public comment from the Seminole Tribe of Florida Tribal Historic Preservation Office Department that I will read for the record. It is important to note, again, this is the Seminole Tribe of Florida. It is important to note that the burden of additional workload should not now or ever have more weight than the burdens placed on tribal beliefs, cultures, and religions for their separation from their ancestors, sacred objects, funerary items, and items of cultural patrimony. Additionally, we should be the ones who decide who our ancestors are. If those custodians of our ancestors do not know who the tribes and descendants are, then they should have no business having custody to take care of, then they should have no business having custody to take care of the ancestors. I would also recommend consulting with tribes. Nearly every tribe in the United States can tell you in detail their ancestral lands. Institutions have had more than 30 years to comply. Assuming the cost and workload is a barrier to compliance is grossly ignorant of the racist colonial policies, procedures. To say that complying with the law is Pollyannish is disappointing sentiment from someone on this committee. Another note to consider, the cost of housing ancestral remains in perpetuity would be significantly greater than the cost of NAGPRA compliance. It is really a disheartening argument. The Seminole Tribe of Florida TIPO department suggests that the membership of the NAGPRA review committee should be revised. It is heavily weighted on the side of colonial science. Increasing the traditional Indian religious leaders to 3 instead of 2 and reducing the number of national museum or scientific organizations to 2 would create a better balance that is more reflective of the purpose and intent of the law itself. As demonstrated today, the discussion concerning the weight of cost and workload speaks for itself. That concludes the public comment of the Seminole Tribe of Florida TIPO department. At this time, I do not see anyone else with a hand raised. You may raise your hand using the Zoom feature, or you may put your name in the chat feature if you'd like to make a public comment. It was a nice musical interlude for our public comment moment. I'll take this moment to remind everyone that the next meeting of the review committee is Monday, May 9th, the same time, 2 p.m. Eastern. At this time, there are no other requests for public comment.
Madam DFO, you will send around to the review committee members a copy of the chat. Thank you. Good to have those comments. If no more public comments, then I just wanted to review what different members have agreed to do. So we've got that. We're all clear on that. Tim is going to work on a recommendation text for the 10.1 of the revised regs, and based on the earlier work that the full committee did in a couple of earlier meetings. I've agreed to take an initial drafting of the updating of the inventories activity and the related ideas we talked about there, and send that to all of the other committee members for an opportunity to edit, suggest other things, or agree with it. I also agreed to send around a message to all the review committee members, asking members to identify topics that they would recommend be part of the what it will be the fiscal year 22, or is it fiscal year 23 that we'll be reporting on? 2022. Okay.
22, and I think the recommendation was just for the 3 members that are leaving the committee. So if there are additional points that John or Honor or Barnaby would like to have included in the report to Congress, that they have the opportunity to provide those at the next meeting before their terms end.
Okay, that's good. Is that, I see Shelby nodding. She was the one that made the suggestion, so, okay. I think that was the extent of it. Any other comments from the review committee at this point, or Madam DFO, do you have anything else you'd like to announce or suggest?
I'll just note for the committee as well as for the public that the materials we received from the UCLA School of Law will be posted to the meeting materials. Unfortunately, it'll need to wait till tomorrow, hopefully, when Mariah is back from jury duty. But once she's here to help me with that, we will get that material posted. I was not able to do it myself today.
Enjoy complying with your civic responsibility. Good luck.
I definitely feel for her.
But that material will be posted publicly as soon as we can. Just for those who might be looking for that PowerPoint presentation especially. And as I mentioned, Lauren and I are still working on identifying a time where the NAGPRA program can host a longer presentation from those law students about their work and their recommendations.
Madam Chair, if we have no, excuse me, if you have no other business, we could probably adjourn slightly early. This will make up for some of the times we've run over.
Certainly. Are there any objections to adjourning?
Okay.
We will adjourn this meeting.
We are adjourned.
We are adjourned.
Be in touch. Have a good week.